The Honorable Judges of the United States Court of Appeals for the 10th Circuit. Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Please be seated. Good morning. We have 4 cases for oral argument this morning, and we appreciate your appearances this morning. But before we start with our cases, we have one other very important preliminary matter. Mr. Wolpert.
Thank you, Your Honor. Before you this morning with a preliminary motion to swear in 4 new members to the bar of our court. Before making the motion, with your permission, I'll introduce our candidates.
You may proceed. Thank you.
Would our candidates for admission please approach the lectern?
I think you should report yours.
These are mine, yeah.
Our candidates for admission this morning are Judge Timkovich's law clerks, Margaret McDonough, a graduate of the University of Texas School of Law and a member of the DC Bar, Peter Lusk, a graduate of Harvard Law School and a member of the Colorado Bar, Colin Studer, a graduate of the University of Kansas School of Law and a member of the Kansas Bar, and Kevin Bocheman, a graduate of the Yale Law School and a member of the Colorado Bar. Before I make the motion and administer the oath, are there any questions or comments from the bench?
Well, I have a lot of, now that you're under oath, I have a lot of questions. But anyway, I'm really happy that this year I have my first Texas law grad with Meg and my first KU grad with Colin. So it's been nice to have some more diverse law schools. I'm okay with Harvard and Yale, but both Kevin and Pete are Air Force Academy grads, and I'm really proud of their service to the country before they decided to, enter into our profession and serve in a different way. So please proceed.
I respectfully move for the admission of these candidates to the bar of the United States Court of Appeals for the 10th Circuit. May I administer the oath?
You may.
Please raise your right hands and repeat after me. I do solemnly swear
I do solemnly swear
that I will conduct myself
that I will conduct myself
as an attorney and counselor of this court
as an attorney and counselor of this court,
uprightly and according to law,
uprightly and according to law,
and that I will support the Constitution of the United States.
and that I will support the Constitution of the United States.
Congratulations.
Congratulations, and thanks for your great help this year so far. Of course, that means you have to pay dues now. Okay, it looks like council are ready. Our first case is 25-5071 United States versus Buzzard. Mr. Truskowski.
Yes, may it please the court, I am Ryan Truskowski, and I represent the appellant, James Buzzard. This is a unique case of ineffective assistance of...
Pull the microphone up a little bit. Thank you.
This is a unique case of ineffective assistance of counsel that has been fully litigated and preserved for direct appeal. As the court knows, the defendant has an unequivocal right to the effective assistance of counsel during the plea bargaining process, and that right was violated in this case. So the original plea offer to the defendant was to section 924-0.
Before we move to the nitty-gritty on, our usual practice is not to entertain a ineffective assistance claim until collateral proceedings. What counsels in this case to deviate from that ordinary practice?
Well, the whole July 13th hearing was about ineffective assistance of counsel, and all of the 2 trial court orders were about ineffective assistance of counsel. So it was raised and, litigated and squarely presented before the district court. The record was developed specifically for this purpose. So that's why it's...
Well, aren't there some fact questions still lingering as to what counsel knew and did or didn't say to your client, those sorts of things?
I would say no. If you look at the record, page 977 at footnote 2, that's the first trial court order on this. The trial court basically noted that it was undisputed that the trial attorney never told the defendant that there was an expiration date for the plea agreement, for the plea offer. So really, I don't think there are any factual.
Didn't the district judge, though, make a finding that there was no expiration date?
It did, and that was incorrect. Because basically,
incorrect, you mean clear error? or-
Well, not even, we don't think we need to get to that. The district court said that there was no explicit fixed expiration date. But Fry only requires a formal offer with a fixed expiration date. So it can be implied. We had an implicit expiration date of June 6th in this case.
Okay, we've segued from whether we should hear IAC now versus later in a collateral proceeding, and we've kind of moved to your other issues. So, I mean, your position is there's no further need for the development of facts to make a determination that your client was ineffectively served by his lawyer in this proceeding.
Correct. And another unique quirk of this case, we don't have to speculate, oh, would the defendant have accepted the offer? Well, we know he would have because he actually signed it in this case. It's already a done deal. The government said it was too late, but it's all a done deal. I don't think there are any remaining factual questions.
Don't we need some factual development about the issue of expiration? Whether or not, in fact, it was an expiration, a plea that could be expired, and whether it was implied or explicit, and you develop those facts by testimony from the attorney in question.
Well, if you look at page 11 of the government's brief, they note that they agree, and it's undisputed, that June 6th was the implied date. So it's not a disputed fact here. And the record doesn't need to be developed anymore because it's not contested.
Don't we need to develop testimony from the attorney in question about various communications that he had with Mr. Buzzard?
Maybe if the defendant was given an independent attorney, that record could have been developed more. So the trial attorney didn't argue any of this because he was conflicted.
Why shouldn't that happen in the ordinary course of events with our case Galloway, that happens in a habeas case?
I'm not familiar with Galloway as I stand.
Galloway is one that says, we don't do this on direct appeal, ineffective assistance of counsel. We wait for a further development of the record.
I'm just saying the record doesn't need to be developed any further.
I know you said that, but you haven't answered my question.
Okay.
What about inquiry of this lawyer in question about what communications he had with Buzzard and what Buzzard understood? Did Buzzard understand it was going to expire?
The trial attorney fell on a sword and admitted he didn't tell the defendant about any expiration dates.
Did he? But we need to know the discussions he had with him. He had discussions about the plea bargain itself.
I would argue that there are no other factual findings need to be made with basically.
Okay.
Well, my understanding of what the district court was trying to do at this hearing was make a determination factually whether there was this expiration date on the 5 to 7 years offer. And it did that with this hearing, this evidentiary hearing, and it determined that there was no expiration date. And in fact, there had been an actual rejection, an explicit rejection of the settlement offer, which I believe was June, you found it was June 20th? Yeah, no, June 1st. There was an explicit rejection of the offer, and after the explicit rejection of the offer by Mr. Buzzard, there was a counteroffer, which would certainly indicate there's no longer, I've rejected this offer, I'm giving you a new counteroffer. I mean, when you explicitly reject an offer, how can you consistently suggest it remains open? And you make a counteroffer after you explicitly reject it.
I don't know. We don't know what the defendant knew on that point. I guess.
Why does it matter what the defendant knew? The district court was saying, was there even an offer outstanding? And the district court said, clearly not. On this day, June 1st, the offer was explicitly rejected by the defendant.
I don't remember that June 1st date. I just know that June 6th was D-Day, no pun intended, and that the defendant didn't know anything
What,
about
and
it.
what was the testimony about June 6th?
Well, if you look at page 11 of the government's brief, their position below and on appeal, that's page 11 of their brief, was that June 6th was the final day that the plea needed to be
Okay.
accepted. And the defendant didn't know anything about this. I mean, really, the problem is here, none of this was looked from the
Even
defendant's.
though the court made a finding that he'd already explicitly rejected the offer by that date. It's a little confusing what's happening here.
Anything that happened after June 6th doesn't really matter from our point
What
of view.
about before June 6th?
I don't think we had any rejection of any offer before June 6th.
Okay, all right. Maybe I've got the timeline wrong, but I know the district court did make a finding of an explicit rejection of the offer and a new counteroffer.
I guess the overall part of this is, I just hope we're not playing word games with the Sixth Amendment in the sense that formal, informal, explicit, implied. I mean, we have to look at this from the defendant's point of view. He did not know about any expiration dates. So when
That was the point. The court was trying to say, if there was no expiration date, there was nothing for him to be informed about.
if there was no expiration date, we wouldn't be here. He would have pled guilty.
Well, that's certainly not the case. We know that he made, even after this offer was open for a couple of months, and he made many counteroffers during this time.
Only in the course of normal plea bargaining, plea negotiations, because he didn't know that he had a final deadline.
And you don't agree that there was a finding that he made an offer, he rejected the offer at some point? That the district court made that finding?
As I stand here, I don't recall
Maybe-
that exactly
right.
within the time
All
frame.
right, thank you.
I'll save any other response for rebuttal, if that's okay.
Okay, thank you, counsel.
May it please the court, Thomas Duncombe for the United States.
Could you clear up Judge Moritz's timeline question
Sure, absolutely.
from your perspective?
And there was a finding to that effect, Judge Moritz. That was the court's written findings following the hearing were at volume 1 at page 1006, and it may have been 1006 and 1007, but that's where you'll find those.
Wasn't that on June
findings.
1st?
And that was on June 1st, and that's also contained within the government's briefing that wasn't disputed by Mr. Buzzard below, which is volume 1 at 960 through 962. That's where the government laid out all those offers and counteroffers and rejections that I believe there were 4 counteroffers from the defense, and I think the
Right.
latest one was June 1st.
That all came up at the hearing?
Yes.
Yeah.
Yes.
And this is all laid out, right?
And yes, and there was no dispute at the hearing about the timeline. In fact, Mr. Buzzard's counsel went out of his way to say, I'm not disputing any of the timeline that Ms. Reininger for the government has laid out. We got to the hearing on June 20th. Ms. Reininger told me that March 30th offer is no longer available. And at that point is when I went to my client and said, let's try to sign it anyway and see if they'll accept it and go back to it, essentially. So what the June 1st
But
rejection,
you did that. I'm sorry, at what point did,
that was June 20th.
June 20th, okay.
June 20th.
Yeah.
So,
When
so
he went back to, and asked if he'd sign it even though it
Yes.
wasn't, you know.
well, he brought it to him and asked him if he would sign it. But we know from several things in the record that that wasn't the first time he had seen that March 30th offer. One of the reasons we know is the June 1st counteroffer. And unless we had a fully fleshed out hearing,
I think June 1st was the actual rejection of the offer according to the district court.
yes, and I want to be,
I mean, that,
I want to make
maybe-
sure that we're
Maybe we're talking
talking about.
about the same thing, maybe a counteroffer, but I got the
Yes.
impression from the district court it was an explicit rejection and then a counteroffer,
Yes,
which is not
and-
the same thing as just making a counteroffer and expecting the offer to still be open.
Well, my recollection is that it was a counteroffer, but a
Okay.
counteroffer rejects
It does
the
reject,
initial
yeah, okay.
offer.
Okay.
So just by standard contract principles, that March 30th offer is only on the table to the extent the government wants to go back and revisit that, which the government can. But in this case, that June 1st counteroffer, what it shows us is it's one of many data points that shows us that the defendant knew about the March 30th offer and knew about it enough to evaluate it and make a counteroffer about it. And it also shows us that on this advanced question that the court didn't get to because it didn't have to, of would the defendant have been prejudiced if there had been a firm expiration date and he wasn't informed about it, the next question under Fry is, well, would the defendant have accepted that offer if he had known about the expiration date? And we know from several data points here that he wouldn't have accepted that offer. The only time he was willing to accept that offer was essentially when it was too late, was the court had denied the motion to dismiss. There had been another pretrial hearing denying some motions in limine that Mr. Buzzard's very conscientious and zealous counsel had brought up. And there was the June 20th hearing where all of the government's difficult to wrangle fact witnesses showed up. And Mr. Buzzard's counsel flew in from Philadelphia to view that and saw that they had all showed up. And that's the only time when Mr. Buzzard showed interest in the offer that he knew had been outstanding since March 30th. The other data point that I would point the court to are the text messages, the actual text messages between Ms. Reininger and Mr. Abreu about the offer. And those are at volume 1 at pages 981 and 982. And you can see Mr. Abreu uses language like, if I could have your response to the motion to dismiss in hand when I go back to talk to him, that would be an additional data point for talking to him about this offer. And he also says, I'll be talking to him more about that deal. So there's every indication from the record, to the extent this court believes that the record is complete as to ineffective assistance of counsel, which we submit it's not, there's every indication from the record that Mr. Buzzard would not be able to make out the deficient performance or prejudice prongs of Strickland.
Was there any testimony from his counsel at this hearing that counsel believed that because they'd been making counteroffers, and each time implicitly or explicitly rejecting the offer, that was a continuing, that was something they could continue to do, which seems to be what you're suggesting happened here, is this?
Yes.
This defendant believed that they could continue to make counteroffers or eventually accept because that's what they were doing. And the
Yes.
offer was never withdrawn. So
Yes,
isn't that a bit contrary to what the district court found then? I mean,
No.
because it turns
Judge
out
Moritz.
there basically was an expiration date where you can't keep making these counteroffers.
No, and there's a difference between the government revoking the offer
Okay.
and there being an expiration date. Because an expiration date, at least as the Supreme Court discussed it in Fry, is essentially, this offer is going to automatically
Okay.
expire by June 1st or by June 2nd.
Okay.
And that's what you needed testimony on because there wasn't anything on the face of the offer itself that would indicate that one way or the other. So
Okay,
we're
so
in
that's
a
it.
factual inquiry about whether there's one of those expiration dates. And in Fry, the defense attorney knew about the expiration date and blew it and didn't tell his client about the offer, let alone, hey, there's an expiration date. And now the defendant lost out on that offer.
Right, right.
So the court found that there was no expiration date, there was a firm revocation on June 20th. And the government, the actions of the government counsel and Mr. Buzzard's counsel are consistent with the findings of the district court, that they continued to act as though they were trying to work out a possible deal. I believe on June 7th at the hearing, the government told the court, we're still in the midst of negotiating. And in fact, on June 20th, when the government revoked the March 30th offer, the government said, we're going to be presenting you with a new offer. And as often happens in these cases, when the government's position improves and when the government's willingness to make a deal decreases as you get closer to trial, that deal was going to be worse for Mr. Buzzard. It was going to be a plea to second-degree murder instead of 924.0 with a cross-reference to the manslaughter guidelines. So I think getting back to where we originally started, which is the ineffective assistance of counsel, I think your honors are 100% correct. Of course, we agree with this in our brief, that the record is not fully developed for review of an ineffective assistance of counsel claim on direct appeal. And this court has said in a number of cases that it's not only a preference of this court to wait until collateral proceedings, but virtually all ineffective assistance of trial counsel claims.
What I don't understand is, you said that in an ineffective assistance habeas claim, or 2255 claim, we would need to know about the pending plea offer, but as to its expiration or non-expiration. And you said, but there's been a finding that there was no expiration date. So what?
Yes.
Why do you need further development of that?
Well, one of the things that this court has said in cases like Galloway and Flood is that you need at the very least some weighing in by defense counsel about whether, if there was an act that on its face appears to have been deficient performance, was there any strategy behind that? And I think, as Judge Timkovich was asking earlier, you would need to get into the nitty-gritty of, what did you say and what did he appear to understand based on what you said? It's not necessarily a black and white issue of, did you say X? Yes. And then you would need to get into an inquiry at the district court of whether the defendant was prejudiced. And we submit that on this record, incomplete as it is on ineffective assistance of counsel, only supports that there was no prejudice to the defendant in the manner that Fry talks about. Because every indication that we have in the record is that the defendant would not have accepted this plea agreement if it had a firm expiration date of June 1st or June 2nd.
But you're talking about the March deal rather
Yes.
than the second-degree murder deal, right?
Yes, and that's what I understand Mr. Buzzard to be focusing his arguments on, is that March 30th plea offer. Mr. Buzzard, to my knowledge, never signed any plea offer for second-degree murder. But if he claims to have done that and claims there was some ineffective assistance with regard to the June 20th second-degree murder offer, then that's yet again a situation that probably even more than the March 30th offer, we would need a hearing in the first instance at the district court and fact-finding. The Massaro case from the Supreme Court says that unless the record is developed precisely for the purpose of conducting an ineffective assistance of counsel.
Is there a minimum mandatory on the second-degree murder?
Not to my knowledge, Your Honor. My understanding of second degree is that it's a maximum life, but that there's no mandatory minimum.
And so you just get a guidelines range, and it's capped at life, right?
I believe so. And there are aggravating circumstances under the second-degree murder guideline, but my understanding is, unlike first-degree murder, there's no mandatory sentence.
Okay, thank you.
Yes. And as we said in our brief, I'll just briefly touch on the right to presence claim itself, which every case that we've found from the Supreme Court and from this court has found that that is the type of claim that's subject to plain error review. It's not a structural error, even when the defendant does have a due process right to attend the proceeding in question. You still have to preserve that. You still have to show prejudice on appeal, and that's the defendant's burden because we're on plain error review. And you need no...
When would the objection have occurred, or when should it have?
Could have occurred at any number of places. Could have occurred when he first found out that the hearing had taken place. There was a publicly filed docket entry on July 13th after the hearing where the court said, we held a hearing, and I'm making the following findings based on this hearing. Defendant could have objected then, just as in Snyder, which was the Justice Cardozo case from 1934, where they went and viewed the crime scene. They took the whole jury out there, they took all the counsel, the bailiffs, the judge. The only one who wasn't there was the defendant. And the Supreme Court said, you could have asked for another viewing of the crime scene if you wanted. You had ample time before trial if you thought anything had been missed of substance. That didn't happen here. The defendant had ample time before trial and after that July 13th hearing to say, wait a minute, there was a hearing and I wasn't there, and I was prejudiced in some way.
But the only issue in that hearing where he was not present was the expiration issue.
Yes, and it was information that was uniquely in the knowledge of the attorneys. And there was nothing that Mr. Buzzard could have added to that discussion on that point, and he has
Did Buzzard
pointed.
know about the hearing before it occurred?
The indication from the record is he did, because in the
What are
June,
those indications?
on July 10th, his counsel filed a motion for the hearing. And he said, this is at volume 1 at page 850. They said in that July 10th motion for hearing, Mr. Buzzard has agreed to execute a waiver of speedy trial to ensure that this inquiry gets done. So it doesn't say explicitly, we've told him that we're asking for a hearing, but in order to ask him if he'd be willing to execute a waiver of speedy trial on this issue, it indicates that they talked to him about the fact that they were requesting a hearing. But the point is, even if he didn't know about the hearing before it took place, he never objected after the hearing. His counsel didn't object
Oh,
at the
it
hearing.
was 4 days before trial, wasn't it?
That sounds right.
Not
That
very-
sounds right.
Not long.
Not long, but this was.
We don't know we don't know. You're suggesting he has constructive knowledge because of the docket entry? Is that what you're saying?
I'm
We don't
suggesting.
know if his counsel, what his counsel told him, whether there had even been a hearing, whether a hearing had been granted.
No, but what this court said in Byerly and in Hardy is that one of the data points for finding that the defendant, that the claim was subject to plain error, and I see that I'm out of time.
Please
May I
continue.
finish? One of the data points that those courts both used was the defendant didn't object to being absent and his counsel didn't object at the hearing to his absence. And so that counts for subjecting his claim to plain error, the fact that his counsel didn't object. And again, if he wants to say that his counsel, as he's argued for the first time on appeal, was ineffective for failing to object, that's something that this court would presumptively dismiss and send to the district court for a collateral proceeding in the first instance. So,
Thank you, counsel.
thank you.
Unless there are other further questions, I'll rest on the briefs.
Okay. Excuse me, I didn't hear that.
Unless there are any other questions, I'll rest on the briefs.
Questions? Counsel will accept your tender, and counsel are excused. Case is submitted.
Yeah.
All right, looks like counsel are ready. This case is 25-3067, United States versus Williams.
Judge Timkovich, and may it please the court, my name is Dan Hansmeyer. I'm with the Kansas Federal Public Defender's Office, and I represent the appellant Edwin Williams. The question presented in this appeal is whether district courts have the statutory authority to include payment language within treatment conditions of supervised release. I guess there's three things going on. We've made a pitch in our reply brief that this can be a really easy case based on what the government said on page 15 of its brief. about not revoking people for failure to pay. If you want to say that and send us all home, you can do that. I assume I didn't fly all the way out to Denver for you to do that, so I'll move on. The second thing is prudential ripeness. I don't want to talk about prudential ripeness. I briefed it exhaustively in my reply brief. I'd prefer to stand on the briefs. Also, if I'm going to lose this appeal, that would be the way to lose it, not on the merits. So if I could just transition to the merits, that's where I'd prefer to spend my limited amount of time. So we think we have text. This is an issue of statutory interpretation. We believe we have the text. We believe we have statutory context. We believe we have statutory history. And we think we have a ton of precedent that supports us in this case. So to start with the text, essentially, this court needs to find statutory authority for courts to do this. We don't think it can. The specific statute that authorizes treatment conditions is 3563B9. That statute says nothing about requiring defendants to pay for their treatment. That matters. Courts do not supply omissions. Supplying omissions transcends the judicial function. We would simply ask you not to supply that omission as a textual matter. That conclusion also flows from
What about B20? And it talks about a process that requires payment by the defendant for the support and maintenance of a child. I know that's a different aspect, but it suggests that some conditions can have a payment obligation.
So I actually disagree with that's the implication. I think the implication from the inclusion of payment language in other provisions within B20 is that Congress intentionally did not include payment language within B9.
Okay, I think that's a good response. What about B22? Quote, satisfy such other conditions as the court may impose.
So, right, I think this is what the district court relied on. I don't think this makes any sense in this case because B22 is a catch-all provision for conditions of probation, and we have a catch-all provision for conditions of supervised release in 3583D. So I think if you want to rely on a catch-all provision, it has to be in 3583D.
I'm sorry, can you explain that again? Why we can't rely on the catch-all in 22?
Well, so
Because you can impose mandatory conditions to satisfy such other conditions as the court may impose.
correct, but that is a catch-all for probationary conditions. And this is supervised release, and the supervised release statute has its own catch-all provision. So essentially, if you were to write an opinion saying we're relying on 3563B22, you just made the catch-all provision in 3583D entirely superfluous. There's just no point if you're going to rely on the other catch-all provision.
So essentially, your argument would indicate that any specific condition has to be specifically authorized in the statute.
That's not true.
Well, then why doesn't 3583D provide all the power the court needs, there's conditions as needed?
Because there's a specific statute that covers treatment conditions. So I'm relying on the specific over general canon of construction and also the canon against surplusage. And so because we have a specific provision that enumerates treatment conditions and that provision does not include payment language, you should not add that language to the specific provision. Now, for conditions that are not enumerated at all, that is what the catch-all provision covers. So for instance, don't associate with gangs. That's not an enumerated condition. I wouldn't stand here and say a court couldn't impose that condition. That would be in any other condition if it satisfies the three factors in D1, D2, and D3. So that's the difference, is that we have the enumerated condition in B9. This is...
Have any authority to suggest that that's how we should read it? If it's not explicit, you don't have authority unless there's explicit authority
Yeah,
granted.
I have a ton of authority.
Okay, what's your best authority?
So in the conditions context, we have this
Yeah.
court's opinion in Prescott
Anything in
Court.
terms of like this type of a payment, though?
Yes.
Okay,
We have
yeah.
this court's opinion in Prescott Court. I mean, that case involved judges, and there's other judges from other circuits about this, on these charitable organizations, courts wanting to
Right.
impose, I don't want to impose a fine, I want you to pay a charitable organization.
That was totally different. That undermined the entire concept of the statute. They were paying corporations instead of the victims, which was the point of the statute.
I don't think it is totally different, because what this court said is the Probation Act did not intend to authorize the district courts to direct the payments of funds as condition of probation beyond the expressed authorizations contained in the statute.
Right, and there was an express authorization that
Well,
it goes to the victims. This was about who it goes to, not
fair
about the
enough.
payment itself. It
Fair
was
enough.
about who it's directed to. That's not our question here. We know what it's directed to.
Well, the principles are the same, though. I mean,
I don't think they are. I think it's about who you can direct a payment to, as opposed to whether you have authority to direct a payment.
and that's the question here.
Anything else besides that case?
We have the Fifth Circuit's opinion in Jimenez about court-appointed counsel fees. I think this is important because there's a statute, 3006A, that allows a judge to impose court-appointed attorney fees. What the Fifth Circuit said is you can't make that a condition of supervised release because it is not authorized by the conditions statutes. That's entirely analogous to what I'm saying here. You have the Ninth Circuit's opinion in Lakatos. That case involved 3563B20, the child support obligations. The district court wanted to did impose child support obligations at a rate different than the state court order. The Ninth Circuit said you can't do that. You have to follow the statute. That's exactly what I'm saying here about 3563B9.
That's different also. I mean, if the statute says follow the state court order and the court says, no, you don't have to follow the state court order, that's not what we have here either. I mean, we have, that's just nothing like this.
I mean, I just completely disagree with you. I mean, 3563B20 says you can impose child support as a condition of supervised release.
Right.
And you have to follow what that provision says. The district court in that case did not follow what the
why didn't
provision
it follow
says. Because it went beyond what the child support obligation was. And what I'm saying is
Right,
the
and it
district-
says it was explicit that you've got to pay, you can pay for this, but you can impose this, but you can only impose it for what we tell you can impose it for. That's not what we're dealing with here.
So I think it
We're dealing with
is.
a condition that's been imposed for treatment, and the court saying, and I'm going to direct you to pay for that treatment. There's nothing here saying you can't impose it, which was essentially explicit in the statutes you're talking about.
I don't think that's right. I think if you read 3563B20, there's nothing explicit saying you cannot depart from the court order. It's a general provision, just like this one, but it doesn't include the specific authorization. We also have Ferguson from the Fifth Circuit. That's about 3563B19 and home detention. The district court in that case imposed a home detention condition outside the scope permitted by that statute. The Fifth Circuit said you can't do that. You have to stick within the scope of the provision. That's exactly what we're saying here. Cotman from the Third Circuit, that involved buy money, and 3563B3 and restitution. They said, buy money isn't restitution. There's no specific provision authorizing the payment of buy money as condition of supervised release, so you can't do it.
I mean, I guess I see what you're saying is if we had a provision here saying, well, you can direct payment of substance abuse treatment, which is one of the orders here, but you can't direct payment for mental health treatment, which we also have here. And the court directed payment for mental health treatment. That would be different than where we simply don't have there's just nothing here as to whether you can or can't direct payment for these two kinds of treatment.
Well, that's true in that absence.
And I think the cases that you talk about, and again, I understand you disagree with me, but they seem to be statutory obligations, or you can direct payment for a particular obligation, and that's explicit what that obligation is. That means you can't go beyond that.
And I think that is what Judge Moritz throughout.
And maybe I understand we're not agreeing on this, so I apologize, but yeah.
I mean, throughout 3563 are payment obligations as discretionary conditions. I mean, they're just there. So but they're not in 3563B9. Now, why would Congress not include them in 3563B9, but include monetary obligations everywhere? And if you're going to if you're going to say that we don't care that it is an absent provision, and we're going to allow courts to require defendants to pay for things that aren't within 3563, then you've just made the payment obligations within 3563 superfluous. There's no point for Congress to put any of that language within the statute if there's some inherent authority for district courts to make defendants pay for things on supervised release. You would just gut, I think, 6 provisions within 3563 if you do this. We haven't talked about 3672.
What are the 6 again?
Excuse me?
What are the 6 payment provisions?
Well, you have restitution, you have fines, you have child support.
What numbers are those?
I think that's a good question.
Restitution's 2.
B3, I think. I think B1 is dependents, support dependents, is that right?
One is
Statute.
dependents.
I can read it.
Sorry.
It's not supposed to be a trick question. I'm looking at it. I'll figure it out.
Yeah, I think
B1 is,
B20,
yeah, dependents.
I want to say
You have to
B1,
support dependents, or you can impose that.
B1, B20, B3, and a couple others. Sorry, I'm not staring at the statute. I'm getting close to my rebuttal time. We haven't talked about 3672. I would just say 3672, the district court didn't rely on it. I don't think you should either. If you were to rely on it, though, I do want to make this last point, then I'll reserve the remainder of my time. The conditions in this case do not comply with 3672. So if you want to go down that route, I think you still have to send this case back. If you look at the record, page 34 to 36, that sort of explains that point.
The Seventh Circuit relying on 3672B, all right?
Yeah,
And- And why shouldn't we rely on that?
Well, a whole host of reasons. So that provision is not what, so if you look at 3672, it does not, I'm going to kill all my time talking about this statute. That's okay.
I'll give you rebuttal.
So
Like
3672.
The previous lawyer gave us extra time, so.
It doesn't exist within the supervised release statutory scheme. One, it doesn't mention conditions of supervised release or otherwise tie reimbursement mechanism to the reimbursement mechanism to supervised release. It doesn't cross-reference or reference 3563 or 3583 or vice versa. And look, the enumerated duties, you would think that so 3672 is structured in these paragraphs, it's not numbered, but you would think that if one paragraph could be a condition of supervised release, they all could. Well, that's not true. Try to make any of those other paragraphs a condition of supervised release, it doesn't work. The second to last paragraph
All
is
right,
not
that-
limited.
That's sufficient. Essentially, you're saying it just doesn't apply to conditions of supervised release. Is that your answer?
That is,
Okay.
if I can make 3, well,
Well, you didn't want to make the points earlier,
Yeah.
so if you want to go to something else, go ahead.
kind of in the groove right now. So I'll just go with it. The other enumerated, so that if you look at the second to last paragraph that talks about ordering treatment, it's not limited to supervised release. It can be someone on pretrial release. It can be someone with incompetency hearings. And then the last paragraph that we're talking about, the reimbursement mechanism, the phrase is, quote, "a person furnished such services," end quote, a person. Again, that's broader than just anyone on supervised release. And I will just, I have other things to
I'll
say.
give you rebuttal, but can you tell me what the fatal flaw in Beagle is, our order and judgment?
Well, probably the defense attorney who argued Beagle would probably be my answer. I mean, that's just not, the argument in Beagle was about a sufficient explanation for the condition. I mean, there was the case essentially came to you as a concession that this is allowed, this is proper. I'm arguing that that concession was wrong. And I just don't know how you take an unpublished opinion about a different issue that, or the attorney conceded the point I'm arguing and say I lose because of it. I really hope you don't do that.
All right, thank you.
Thanks.
We'll hear from the government.
morning, Your Honors. May it please the court, Jared Mag on behalf of the United States. Your Honors, a district court's decision to require a defendant to assist in the costs of treatment imposed as a special condition of supervised release is supported by the relevant provisions of 3553A, 3563, 3583D, and 3672. The defendant's facial challenge alleging that no authorization exists for such a condition must be rejected here. Now, apart from his decision not to challenge the underlying programming and drug treatment imposed as a condition of supervised release, the requirement that he also pay the cost of this treatment, if he is financially able to do so, is consistent with the relevant factors of 3553A and not inconsistent with guideline policy, which aims to look at the individualized treatment of a defendant in each instance. The district court's authority to impose the financial requirement is contemplated by 3583D. There, Congress plainly stated that a district court may order any condition set forth as a discretionary condition of Section 3563B and any other condition it considers to be appropriate to the extent that the condition satisfies the factors under 3553A, does not impose any greater deprivation of liberty, and is consistent with the policy statements of the condition. Simply put, 3583D allows for a special condition consistent with the factors of 3553A, and a district court does not run afoul of the law by imposing an additional cost incentive that will positively influence defendants' efforts at reintegration and rehabilitation. Now, make no mistake, the government stands in support of a defendant's recovery during the term of supervised release. The requirement that the defendant be required to possibly pay in support of his own treatment leads to greater success. Judge Murphy, I think you hit probably on the point that the government is relying on mostly, is that 3583D really sets the groundwork for how this particular special provision is to be analyzed. Congress clearly gave the courts broad discretion in establishing special conditions. That language is seen both in 3583D and 3563B. That broad discretion allows for an individualized assessment of a defendant to determine whether or not their ability to assist in their own, in sense of their own treatment in the payment, if they're able to do so, is certainly not something that can run afoul of 3583D, because it sets the benchmark, or it sets the groundwork for the provisions that the court has to meet. It has to look at the 3553A factors, has to determine if there's a deprivation of liberty, and it has to determine if any of the, if that particular provision would run afoul of the policy guidelines.
The district court didn't really do that here. I mean, it discussed the language, but I didn't really see any real analysis of the factors. It just recited some language and that it was no greater deprivation of liberty interest. And, in fact, the court even seemed to sort of hedge on that, and he said, when talking about whether there was a greater deprivation of liberty than reasonably necessary, Judge Crabtree said, well, we can't tell now. We don't really know because we can't tell now whether he'll be asked to pay. I thought that was a little bit odd.
Yeah, I think the lower court's sort of analysis in looking at this it certainly wasn't, I guess it was understandable that Judge Crabtree might have had some confusion about whether or not the defendant was asking in this instance as to whether or not the issue was, could he pay? Because of course that is the provision. Is he financially able to do so? And
right.
When Judge Crabtree is looking at that, he seemed to get, to look at that issue maybe as a condition that would come up later.
Right.
And that seemed to be his concern. But I would disagree that he didn't give full consideration to the issue of whether or not the underlying conditions were appropriate. Certainly there's...
Well, he basically said it's appropriate because I've imposed these treatment conditions, and so it's related to that, essentially.
But he does go
He didn't
through-
say very much.
He does go through the fact that the defendant had a drug history.
Sure, But that supports, that doesn't really support the payment part of it. I didn't understand the connection there. And
Well-
I think you've tried to make one by suggesting, in your briefing and citing to a case or two that suggests that if the defendant has some skin in the game, well, then he's more invested or in the treatment. But there was nothing like that from the district court, nothing at all.
Right, he falls back on the Beagle decision sort of as a basis to
Right.
find.
And what
that-
about
that-
the Beagle decision? What does it really tell us?
Well, it at least gives some indication that this court, in looking at Beagle, did not seem to raise any concerns with the fact that this type of payment could be made.
Of course, that wasn't argued.
It wasn't
It
necessarily
really is pretty
argued.
meaningless.
That's why I would sort of point, as Your Honor sort of alluded to, I'd point the court to the Hines decision as a more appropriate decision to look at in terms of relevance. Certainly, it's only persuasive, it's not this circuit, but at the end of the day, the Hines court certainly looked at this in the exact posture that the defendant brings the case today. There in Hines, the defendant raised the issue, particularly of whether or not this provision ran afoul of congressional authority to be able to allow for this to happen. And they fell back on 3672 as a basis.
Right,
We understand
and I think that, Appellant makes a pretty good argument that 3672 really can't be applicable here, can it?
That's an interesting question.
They didn't really
because
analyze that,
To some
Seventh
degree, and counsel can certainly correct me if I'm wrong here, but they seem to suggest that if the court were to restructure the order, if this were to be sent back and the court were to restructure the order, it certainly would be allowed to make this provision just writing it in a different format. So it's sort of 6 1/2 dozen the other. You can either order it through the special provision as a special condition, or you can simply separate it out into a particular order itself under 3672. So that, to me, I think there's an appreciation for the fact that Congress did authorize this. The courts looked at it as, well, if we're going to use a vehicle to impose this type of payment, 3672 certainly allows for that vehicle to exist. And the court being able to do that under 3583D as a measure, as a part of a special condition certainly fits within the court's authority. Because one, under 3553A, as we argue, it certainly incentivizes the defendant, and we believe it meets all of the factors under 3553A because, again, he has skin in the game to make sure that that treatment is followed through, gives him an opportunity to better his integration. And so it is certainly a factor that the government believes, and certainly has been stated in other cases, that this incentive is important for a defendant to succeed. We're not standing here trying to suggest that this payment is some sort of a fine or anything. This is something that the government truly believes in because we stand with the defendant to ensure that they have the best way to succeed on supervised release. And giving the district court the authority to impose a special condition like this certainly lends itself to the defendant being able to do so. So at the end of the day, if the court were to find that somehow this violates the statute in the way that the defendant says, it would certainly beg the question about whether or not the district court could just simply reform the language itself to fit 3672. And again, you're getting to the exact same issue. The defendant associating him or being able to provide for costs toward his own treatment if he is financially able to do so.
Do you, I know the government didn't rely on 3563B22. The district court brought that up sua sponte. Are you suggesting that somehow supports its probation of conditions?
Only to the extent that it gives some sort of congressional intent on the idea that there is a much broader discretion when you're getting into the conditions that someone is being given by the district court in these, both on a probationary status and a supervised release. And again, I don't think that should be undervalued here because congressional intent really is, in the broader sense here, the idea that the district courts must look at each defendant in an individualized way. If you begin to cabin that discretion, you start to treat every defendant the same way. Congress certainly didn't want that to happen. It set the groundwork and set the parameters under 3583D by setting those 3 criteria that the court must meet. And again, our position is that when someone is told that they must assist in the payment. If they can do so, it certainly incentivizes them to be able to succeed on supervised release.
Well, there certainly are plenty of other conditions in the statute where the Congress has specifically made it clear you can impose payment obligations. What does that mean? Does it mean the opposite can't be true, that, you've got to have, if you don't have authority, you can't impose them?
We don't believe so because
And can you address some of the case law that Mr. Hansmeier was discussing that he said was analogous?
Our position, again, is that 3583D drives this, that it isn't 3563 that drives the understanding. Certainly, Congress, when looking at the probationary factors, made a determination that there has to be certain payments under certain circumstances. Again, many of those are tied to the conviction themselves necessarily, but not all of them. But 3583D, knowing that in terms of supervised release, that each individual defendant may have particular factors that they have to reach, set the gates that must be met, and those are 3553, deprivation of liberty, and policy considerations under the guidelines. That is the only analysis that we believe that the court must go through. I think the court can divorce itself of 3563 in that instance, and therefore anything under 3563 really doesn't have as much impact here as 3583D. I think what the defendant wants the court to look at is that those two statutes have to be read together in a way to establish congressional intent. But 3583D drives supervised release analysis.
Is this, or is the payment scheme, is that standard practice for the District of Kansas judges?
I don't want to speak for the entire district, Judge. I don't know. I will tell you in researching this issue, this seems to be at least a common factor amongst districts across the United States. How uniform that is, it's hard to say, because in a lot of instances, I think you have to look at it in terms of, is it uniform in the context of everybody who is getting treatment? Certainly, there are going to be individual defendants where there's no treatment issue. But in terms of this particular language being uniform across the district, it certainly does come up quite often. I would say it's probably used more often than not under the circumstances. Most of the judges in the district, at least in the cases that I have handled, that language is incorporated into the overall supervised release provision.
Can you respond to the argument that is made in the reply brief? I know you haven't had a chance to respond, that the government somehow conceded when you said in your brief that nothing suggests from the record of the district court's order that any failure by the defendant to contribute is a standalone violation that could potentially cause a revocation of supervised release. Now, I don't really need you to address whether that's a concession or not. I do wonder if that isn't an incorrect statement of the law. I mean, if you make it a mandatory condition of release, it certainly could be a standalone basis for revocation if he doesn't pay as directed, couldn't it?
We again, to sort of alleviate any confusion, yes. What I was trying to simply suggest is that the highly unlikelihood of that occurring under the circumstances of an individual who could show indigency. But I would agree with the court that in the event that a district court had someone, say, who was quite wealthy, certainly could
Or maybe
impose
not
that.
quite wealthy, maybe just has the ability to pay something. That's really not what the what the condition requires.
Not
But you have to
necessarily.
be quite wealthy.
Right, and again, we're coming at it from a practical standpoint, and quite frankly, we've not seen, at least had a situation, and that sort of drove the issue about whether or not there was a rightness issue, as to
Right.
whether or not there were conditions that needed to be established before this question really was something that was appropriate to bring to the court. To clear up that issue, to be very clear, it looks like in the reply brief, the defendant himself is sort of arguing now without any issue that this is strictly a facial challenge to the statute. If that is the case, the government would concede that there is no rightness issue for the court to address. That if the court is only going to address the issue of whether or not there's authority under the statute, this is right before the court. Judge, I want to be as completely responsive to your question with respect to the issue of whether or not it's a standalone reason to go ahead and reject or to revoke someone's supervised release. Again, we made that argument to some degree under the ripeness issue to try to suggest that that's an issue that would come up at a later time. But at the same point, we do concede that at the end of the day, a district court could do that.
Could be, right.
We just simply suggest that
All right,
it's
thank you.
highly unlikely.
I appreciate your acknowledgement of that.
I see that I am exactly out of time. Unless there are further courts, we would ask the court to affirm the court's decision to impose this condition.
Thank you, counsel. And Kevin, could you give 3 minutes?
Thank you. Let me just try to make a few real quick points and then maybe 2 broader points. So I think Jared just said we're making a facial challenge to a statute. Nope, we are not doing that. So please don't think I'm making any facial challenge to any statute. We're just challenging statutory authority for this particular type of condition. On the ground, I hope you all don't think that just rich people make these payments. I think, from just anecdotally, poor folks pay for treatment in Kansas. There's a copay system. They do. That's how I understand it. That's why I'm here. I represent poor people. The reason why 3563B matters is because it's cross-referenced in 3583D. That's why we get to 3563B, and that's why I'm talking about 3563B9. On this, so I have not conceded at all. Hopefully you know this. I have not conceded that 3672 is the statute you should rely on. That's not true. I don't think you should. My only point was that if you're going to go down the Seventh Circuit's path, this particular condition is not consistent with 3672. That was my point. But there is a difference, and just to be clear, there is a difference between reimbursement and the threat of revocation for the failure to pay. What I am saying is that 3672 authorizes reimbursement at some later date, and that could be even after the person is not on supervised release, which is much more likely that they would have money to pay when they're further along in their lives post-prison. My only point is that they shouldn't be under the threat of revocation for failing to pay. And I think that's what all signs point to that when you read the statutes, the relevant statutes, the context, the history, all of it points that way. On 3583D, with my last minute, if that's the provision we're talking about here, this catch-all provision, first, we're still in the specific over general problem where we have a specific provision on treatment conditions that does not include payment language. We still have the surplusage problem that if you're going to allow a catch-all provision, monetary obligation, you still have all of the enumerated monetary obligations that become surplusage. And if you look at the 3583D 1 through 3, this idea, the Seventh Circuit relies on this self-evident proposition that people love to pay for things they're ordered. Poor people love to pay for things that that they have to pay for. Court tells them to pay for. I don't know why the Seventh Circuit thinks that. There are other circuits, I think the Third Circuit, the Ninth Circuit, this is in our briefs on page 36, Eiler and Evans have rejected that reasoning. I think you should too. Also 3583D3, there is nothing in the guidelines that authorizes payment language, and so that doesn't work either. Thank you for the extra time.
You're welcome. Thanks for the fine arguments. Counselor excused and the case will be submitted. And I think we'll take one more argument and then we'll take a break. All right, looks like council are ready. This is 24-7100 United States versus Barker. Mr. Pincus, you may enter an appearance and proceed.
Thank you, Your Honor. May it please the court, my name is Howard Pincus from the Federal Public Defender, and I represent Coker Barker. The Confrontation Clause prevented the introduction of William Lozier's prior testimony at Mr. Barker's murder trial, unless the prosecution proved Mr. Lozier was unavailable. But the prosecution did not show it was unable to locate Mr. Lozier despite reasonable efforts. What it offered about contact with his family was too vague to show its efforts to locate him that way were reasonable. And in two other regards, its efforts were minimal and on their face were not reasonable. The district court therefore violated the Sixth Amendment by admitting Mr. Lozier's prior testimony, and this court should vacate his convictions. William Lozier's testimony played an important role in the prosecution's case here. The prior testimony put Mikkel Kilo's car at the Barker Little House on the night he was killed. It said that Mr. Barker had told Mr. Lozier that he was interrogating somebody and to look out for the police. It recounted Mr. Barker's admission later that night that he and Ms. Little had, quote, beat him to death, unquote, and that they had dumped the body and shot the person in the head. No trial witness put Mr. Kilo at the Barker Little House that night or testified to a clear admission that Mr. Barker had, that he was involved in the killing. And Mr. Lozier's prior testimony also linked Mr. Barker to incriminating jail notes that the prosecutor touted as important evidence in this case. The serious nature of the charges and the importance of Mr. Lozier's prior testimony each independently called for increased effort by the prosecution to locate Mr. Lozier before he could be determined to be unavailable. And they bear on what this court has said is a good measure of what is reasonably expected of the prosecution. It had to make the same efforts to locate and secure Mr. Lozier at trial that it would have put forth if it did not have his prior testimony. The prosecution did present a report that recounted contact with Mr. Lozier's family. It recited that at the request of the FBI agent, a deputy sheriff had reached out to William Lozier's family, which had not seen him in months. But the report did not say with whom the deputy had spoken. It did not give a relationship of that relative to Mr. Lozier or provide any indication of how close that person was to Mr. Lozier or the likelihood that the person would be in contact with Mr. Lozier. And the report also did not provide a time frame. This was too vague to show that Deputy Brooks had made reasonable efforts to locate Mr. Lozier through his family. Perhaps a single contact with a family member of unknown closeness to Mr. Lozier at an unknown time provides no basis to believe that the prosecution made reasonable efforts to locate Mr. Lozier through his family. It certainly does not show that the prosecution made the same effort in this regard that it would have done if it did not have the backstop of Mr. Lozier's prior testimony to use in its case. In two other areas, the prosecution identified, the record shows that what it did was not in fact reasonable efforts to locate Mr. Lozier. The first of these is what the prosecution did with what it said was where it believed Mr. Lozier might be staying in the week before trial. All the authorities did was go to that house a single time and knock on the door. They did nothing more when there was no answer. They did not try another visit to the house. They did not try to ask any neighbors if they had seen Mr. Lozier or had any information about him. Doing nothing when there
But
was...
did they have some information that this gentleman had been taken to a shelter in Oklahoma City at one point, and he's pretty much transient in nature? He hadn't showed up for an uncle's funeral, according to the family. Oh, he hadn't shown up for, sorry about that, guys. He hadn't shown up for his uncle's funeral, which his family said was very strange. They hadn't seen him for months. Whoever it was, hadn't seen him for months.
Well, we don't know when that was.
Well, I
number
understand
one.
that. I understand that. But this is a transient person who's got 2 bench warrants out for his arrest. They apparently tried to call some homeless shelters. They knew he was at a homeless shelter at one point, taken there by a family member. This isn't like we've got a person who's living at a residence and we believe that he's there and we ought to be able to just go and find him.
Well, the prosecution, its supplements said that it had reason to believe that he was living at a particular address.
And that's the one that they went and checked one time.
They knocked on the door and they did nothing more. They didn't go back another time. We don't even know what time of day it was. They saw that there was no mail addressed to him there, the 2 pieces of mail, but even the government doesn't rely on that.
Yeah.
There's no evidence they spoke to any neighbors. They did nothing to
Right.
really, other than knock on the door.
What's your
That's not
best
proof.
case that would indicate that that this idea of vagueness, that they took all these various actions, but we don't have specifics on them, and that you've got to have some fairly fine detail here? Who,
Harbin-
what, when, where, how, with respect to many of these different acts.
Harbin from the Eighth Circuit talks about how general statements without detail are not enough. And this court in Cook talked about how perfunctory efforts are not enough to meet what is a reasonably high good faith standard in this context.
What were the general statements in Harbin?
I don't recall off the top of my head
Just
what the
wondering
general
if they were
statements were.
analogous here
Yeah.
to what we
But this,
have
it's
here.
hard to imagine anything more general than I spoke to a family member. You know, we don't know who that person was. It's unlike the cases the government relies on here, where there was talk.
Well, it
where
was
we
somebody
know
who knew
they spoke
that,
to.
somebody who knew that the uncle had died, and it was very odd that he hadn't shown up and that he hadn't been seen for 2 months.
Sure,
Somebody with
somebody-
enough
some-
information about him to know that this was unusual.
Certainly
and
a
he
family
had kind of
member.
disappeared.
But it could have been a second cousin, or
Okay.
it could have been a brother, could have been a father. We have no idea. And it's the government's burden to make this showing. As this court said in Cook, if there's any uncertainty, that cuts against the government, which is the proponent of the unavailability showing, and remember, this showing allows prior testimony to be used and deprives the person of the right of confrontation. So Mr. Barker did not have the jury able to see Mr. Lozier testify, to adjust his questioning in light of the jury's apparent reaction to the witness, didn't have that face-to-face confrontation that's so important for the Sixth Amendment right. In terms of the homeless shelters, that's a logical place to look for somebody who's homeless. But what the government, there's no showing here that the government did anything more than make calls to 3 shelters, perhaps a single call. They didn't reach out to the websites, look at the websites and perhaps email, which at least for 2 of them was available back at the time of trial. They didn't go to the shelter, which would be the obvious and easy way to see if somebody was there, and to speak to staff and residents to find out whether Mr. Lozier had been there and what information they might have about him.
Is it your position that all they did was to call in to the 3 shelters and nobody answered the phone?
Well, and that's what this statement says. It says that calls were made to 3 shelters and the calls were unanswered. So if the government had needed...
That's all we have on evidence of their efforts to reach out to shelters.
That is all we have, yes. And that they only did that after the court said he was dropped off at a shelter. Have you gone there and looked for him?
Did the court say, have you gone there to look, or have you checked with the shelters?
Perhaps have you checked into that? Have you looked into that? But they did find out that there was no shelter around Tinker Air Force Base, but it was logical to look for other shelters in the Oklahoma City area. They made perhaps a single call to 3. There were 3 more at that time where Mr. Lozier could have been staying, and they apparently made no effort at all with respect to those.
Is there anything in the record that indicate that Mr. Lozier had a history of using shelters?
Other than the fact that a relative said he asked to be dropped off at a shelter, no. But again, this is a likely place to look for somebody, and the government had an agent actually call the shelters. So the government evidently agreed that a homeless shelter is an obvious place to look for somebody who's homeless. The failing is how little they did in that regard. Making a single call that went unanswered and then nothing more is not at all reasonable. And it's certainly not what the government would have done if it didn't have Mr. Lozier's prior testimony and needed him, an important witness, for this murder trial. And that's what has to happen. They have to that's the good measure of reasonableness. What efforts would they have made if they didn't have the backstop of Lozier's prior testimony and needed him for its case at trial? They can't do less when what's at stake is Mr. Barker's confrontation rights.
Can I switch gears a little bit?
Sure.
On you and talk about it was a preliminary hearing in the state court for Ms. Little where Mr. Lozier testified?
It was a preliminary hearing in state court, yes.
Yes.
I think it was for both of them.
And Mr. Barker was there?
Certainly he was represented there, yes.
And as I understand it, he had the right to cross-examine.
He did. We are not, there was an argument.
I
I'm
understand
sorry.
you're not contesting that.
Yeah.
I'm getting to the harmless error.
Okay.
I mean, his testimony on paper is devastating, correct?
His testimony on paper is devastating, which is why he needs to be able to cross-examine.
There's prejudice here is because the jury could not look into the witness's eyes. They couldn't see the witness live. I'm not sure I see how that's going to detract from this testimony that he gave about the notes when there's fingerprints all over them and there's little they could do with his cross-examination. And in fact, Barker chose to do nothing at the hearing.
You know, he did cross-examine on some things at the hearing, but
So we do have that cross-examination that would be available.
we do, and we have that there always has to be at least an opportunity for cross-examination from prior testimony introduced.
So we have to assume that lawyer did the best job that lawyer could in cross-examining.
At that time, with the limited information, we're not saying that doesn't suffice for, to allow his prior testimony introduced if he's unavailable. And
Okay, but wait a minute. You not only had Mr. Lozier testifying orally, but you had the papers, right, with his fingerprints all over it.
We did, but let me get back to the first part about the importance of face-to-face confrontation. That is a critical aspect of the confrontation clause before the jury. So this jury could make a determination. As the Supreme Court said, I think, in Coy, look me in the eye and say that. I think that's how Justice Scalia started the opinion. He had the right to have the jury, which was deciding his actual guilt on murder, be able to determine whether it believed, by seeing Mr. Lozier live, whether it believed his accusations. And in terms of
But let me, there was independent evidentiary support for what Mr. Lozier was saying, quite independent of his own testimony, correct?
I'm not sure what you're referring to. If you're referring to the notes, I do want to address that. The kites.
I am talking about the notes.
Okay. The kites, even Mr. Lozier's preliminary hearing testimony linked the kites to the supposed kites to Mr. Barker. He said, I got them from him. Okay. Even the government, when it says, without Lozier's testimony, this is the evidence we had, doesn't refer to the kites. Mr. Lozier, who was facing charges himself and was hoping for leniency from cooperating with the government, may have written those kites himself. We just don't know. And it's also
But wasn't there forensic evidence that Barker had touched and passed the notes?
Yes, and we have no idea whether they shared a cell, what the access was in that jail, whether Mr. Lozier could have gotten the paper from Mr. Barker.
What I think you need to address is that notes that support Lozier's testimony have an indication that Mr. Barker had handled those notes.
Not handled those notes, handled that paper.
That
They could have been in the same cell.
You mean they
and he could have taken the paper.
added the notes after he passed a blank piece of paper to somebody?
Not that he passed a blank piece of paper, but that Mr. Lozier had access to the blank piece of paper. And the government could certainly have tried to disprove that. Or they said they had a handwriting analyst, but they never produced one at trial. That's the easiest way to show that this is Mr. Barker's handwriting, but they didn't do that, and they
What,
didn't do that.
what
with
was the
respect to little.
cross-examination at the preliminary hearing? What about the kites?
I'm not sure
What
there was.
came out of that? Was
I'm
there
not-
anything?
I'm not sure that there was. But certainly, they didn't go into this level of detail, which my point is that we just don't know from the trial testimony what the kites were actually written by Mr. Barker. And that's critical. And his hearing testimony, even if there was cross-examination with it, is not enough if he's available. The jury still has the right to look him in the eye and make its own credibility determination about him, regardless of what was said at the preliminary hearing.
Do you have any authority that suggests in any way that when you're talking about the confrontation clause, is that there's a heavier burden for the prosecution to show that the error was harmless?
Well, it's a constitutional violation, so of course
I
they have to show
understand, but do
harmless
you have
beyond
any
reason.
specific authority that says, when you're talking about the confrontation clause, the concept of harmless error has a totally different complexion?
I'm not sure it has a totally different complexion, but it's the traditional harmless beyond a
You
reasonable
don't
doubt.
have any authority indicating that harmless error is treated differently under confrontation clause cases than it is under other cases?
Other than, you mean more strictly than harmless beyond a reasonable doubt? No.
Yeah.
Yeah. But it still has to be shown to be harmless beyond a reasonable doubt, and that's a very strict requirement, and the government does virtually nothing here to try to meet its burden. It's not our burden to disprove harmless beyond a reasonable doubt. It's the government's burden to show it's harmless beyond a reasonable doubt, and they've utterly failed to do that. So I'm way over. We would ask.
You are, I'll give you some rebuttal there.
Okay. We would ask the court to vacate Mr. Barker's convictions and remand for a new trial.
All right, thank you, counsel. Let's hear from the government.
May it please the court, good morning. Jared Lehman on behalf of the United States. Your Honor, I want to start with one of the questions about visiting the residence of Mr. Lozier, and I'll read from one of the 302 reports dated March 28th of 2023. It's in the record at page 273. The house on Giselle Street, which is the house that they visited, had been a rental by Lozier's former girlfriend approximately 4 to 5 years ago. So when they went and visited this house on the eve of trial, it was not where the defendant was currently living. So it was a prior residence that the witness, Mr. Lozier, had occupied with his girlfriend, and that was years in the past. So I want to make sure that we're clear on that.
I take it that was the only address that they had for him?
That's correct, Your
I mean,
Honor.
he was transient or believed to be transient at that time.
Yes, Your Honor, that's
Right.
correct. Regrettably, I did not put a timeline.
So your
this-
suggestion is there really wouldn't have been any reason to keep going back to that house because they had no reason to believe he was there necessarily,
That's right, Your Honor.
just to check.
The government, as my reading of the record shows, the United States government's first contact with Mr. Lozier was in March of 2022, and that's in an interview. In that interview, he identifies himself as homeless. However, he says, I can get mail at a location known as Diversion Hub. And that's important because they do contact Diversion Hub later, and they say that they've never heard of Mr. Lozier before. He also says, you can contact me through my lawyer. He's represented in an ancillary matter that doesn't have anything to do with this federal murder that's occurred. But in 2022, that's what he identifies himself as. I'm homeless. You can contact me at Diversion Hub. Also, please call my lawyer if you want to get in touch with me. She knows where I'm at. The United States keeps in contact with that lawyer who doesn't know where her client is at. And in fact, she makes a statement to the effect of, listen, if he gets picked up by another agency, I'll definitely let you know, meaning you, the FBI, know that he's been apprehended so you can come serve him this trial subpoena.
How long after that was the little preliminary hearing?
The state preliminary hearing, Your Honor, so the offense conduct is April of 2019. The state prelim is June of 2020. The FBI's, as it was, the United States indicts the defendant in May of 21. The FBI's contact with Mr. Lozier the first time is in March of 22. And that's when he tells them, I have this lawyer.
Do we know where they found him in 2022?
Your Honor, the record does not indicate how they found him in 2022. I'm sorry, those facts just don't exist in the record before us. Continuing on with their attempts to contact Mr. Lozier, they contact his lawyer again, they contact his probation officer, they contact the Seminole Police Department, which is where he lived, they contact an ATF task force officer in attempts to contact this gentleman, and they just simply can't find the guy. And I really want to dive down into this concept that we should have done more with the homeless shelters. Originally, there was some information from the family that they dropped him off in a homeless shelter.
When was that?
The original homeless shelter family statement was going to be in March of 2023. We follow up with that family member also in March of 2023, and that family member clarifies, well, it wasn't really a homeless shelter, and I'm paraphrasing here. We took him to Tinker Air Force Base, which is in the Oklahoma City metro area, and just kind of dropped him off there. There's never a statement from the family affirmatively, we dropped him off at a homeless shelter. They instead clarified, we dropped him off near Tinker Air Force Base. And in response to that, the FBI contacted Tinker Air Force Base, hadn't seen or heard from the witness, contacted the Oklahoma County Sheriff's Department, which shares some jurisdiction around Tinker Air Force Base, had not seen or heard from the witness, contacted the Midwest City and Del City Police Departments, which abut the Tinker Air Force Base in many areas. No contact with the defendant or the witness in those instances either. The FBI goes on, contacts the Oklahoma City Police Department, who says, yes, we have had a contact, but when you look at the record, that contact was in July of 2022. So this is, a year prior almost, when the Oklahoma City Police Department had a contact with him. And the Oklahoma City Police Department's documents show that he was transient, but did list a phone number. The FBI called that phone number, and unfortunately, it was no longer in service. So in sum, the government has contacted several different police departments, about a half dozen by my count. They've contacted the witness's attorney, who he said, please contact me. They contacted the diversion hub location where he said he could receive mail, and they had either never heard of him or he was no longer there. They went to the last known address that the witness had. Unfortunately, that was years in the past that he was known to live there, but he is homeless after all. But regardless, the FBI tried and certainly went to that location in an effort to find him. Couldn't find it, spoke to the family a number of times, and I appreciate the record doesn't indicate what degree of family they spoke to, but nonetheless, they were in contact with family of the witness, and unfortunately, they hadn't seen him. Further, keep in mind, against this entire backdrop, the witness has warrants for his arrest. If any law enforcement officer would have encountered this witness, surely something would have come up, but unfortunately, the witness was just, I'm not going to say he's hiding, but he was just transient, if you will. And that doesn't mean that the government has the ability to find somebody. There was nowhere else for the government to look. There was no rock left to turn over.
Okay, you indicated that the Tinker Air Force Base stuff was not specifically vis-a-vis a close shelter or anything, correct? Did the first time the question of the suggestion that you should check with homeless shelters, was it the first time that happened was when the district court stated that?
Your Honor, I believe that's what the record indicates. There's an original report to the effect of we dropped him off at a homeless shelter. The district court, when they're doing their pretrial motions, say, hey, government, the district court tells the government, hey, I want you to look into that homeless shelter thing a little bit more. The government then re-interviews the family.
That's independent of dropping him off by Tinker Air Force Base.
We learned that after the district court ordered us to investigate it a little bit more. So we have the original, Your Honor, we'd like to use this transcript. The witness is unavailable. We have a hearing on the matter. The district court reserves judgment on that issue and says, hey, government, I want you to go look into the homeless shelter thing a little bit more. The FBI then re-interviews the family and gets a more definite statement that, hey, what we actually did was dropped him off near Tinker Air Force Base, not at a homeless shelter. We just assumed that's where he was going. In response to that, they contact the Tinker Air Force Base, the abutting police departments, and then they also call 3 homeless shelters on the phone in the Oklahoma City area in response to the district court's inquiry. The government then refiles its motion.
They never talked to anybody at those shelters.
The record does not indicate that anyone ever answered the phone, Your Honor, so correct. No one was actually spoken to by the government at the shelters. After that,
Should they have done a little bit more on, paid a visit to the shelter? I'm sure that staff, I mean, I doubt if we called the Denver homeless shelter today, we'd get much response. It seems like the nature of the situation is an on-site visit might be kind of your basic investigative approach.
if there had been any indication that the witness was at the shelter, absolutely. But that turned out to be kind of a false flag or something along those lines. It just wasn't true that he was ever at a homeless shelter. And so there's no way to know that he was there. So it would have been an absolutely futile effort for the government
Might
to.
they have done it if they didn't have his preliminary hearing testimony and were really needing this guy?
Your Honor, I can't imagine anything else left for them to do. I really.
Other than go to the homeless shelter directly?
I don't know that they would have done that. I can't represent to the court that they would have done that simply because there was no
Well,
one.
that's the question.
I
The
don't
Cook
think-
test is,
They
would they have
could-
done more if they didn't have his preliminary hearing testimony?
Certainly, they could have gone to the homeless shelters, but I don't know that they would have. It's not a place that would have come up in their investigation to go look, because the family said, we didn't drop him off at a homeless shelter. We dropped him outside of Tinker Air Force Base, and that's where the FBI looked, at his last known location. So I can't represent to the court that they would have actually gone had we not had the backdrop of his state-level preliminary hearing transcript.
After the district court suggested contacting homeless shelters, something was done, was there a hearing where you reported back to the prosecutor, reported back to the district court as to what specifically they'd done vis-a-vis shelters?
Yes, there wasn't a hearing in the traditional sense, Your Honor. As I read the record, my understanding is the government resubmitted its motion to use the witness's testimony and made attachments of the FBI 302s of the government's attempt to go and locate the witness again, and specifically included the reference to the homeless shelter. In response to that, the district court issued an order saying, okay, I'm going to allow the transcript to be read, and the defendant, Mr. Coker-Barker, filed a standing objection to that order. So that
It was just paper back and forth. There was no live engagement on the issue in court.
That's my reading of the record. However, Your Honor, I will say that the parties were actively discussing this. If you read kind of the gray space in the transcript when the jury's out, they're actively discussing this transcript, how they're going to read it, how they're going to get it in, right at jury selection. They're discussing it at breaks during the trial. The transcript itself isn't read until, I believe, day 3 of the trial. So it's a near constant topic of discussion throughout the recesses, if you will, of the trial in the space outside of the jury. So it's something that's talked about very frequently, Your Honor. And I will add in response, the defendant filed a trial brief, if you will, with the court, the district court, after it issued the order saying, hey, we want to impeach with some things that maybe didn't come up in the transcript. And so there was a number of filings and discussions throughout the case about Mr. Lozier's testimony. If there's no further questions, I'm inclined to cede my time, and I would ask that this court affirm the defendant's conviction and sentence.
One thing, are you persisting in your position that the objection was not preserved?
Your Honor, the defendant had ample opportunity.
With my own, I've read it all. I've heard what you said in paper. Are you persisting in that position today?
Yes, sir.
All right.
Thank you, counsel. Could you give Mr. Pink, counsel's excused, appreciate the session. Could you give Mr. Pincus 2 minutes?
Just quickly on the preservation, if you look at Volume 1 at 262 to 263, the district court understood that this was a confrontation clause claim. In terms of what the government said about the house on Gazelle Street, this is not what they said in the district court. There they said the house on Gazelle Street, they attempted to locate Lozier at a house where it was believed he might be staying. They had both of the exhibits then. They didn't make this claim that those were the one in the same house, and there's no way to tell that from the record. And we can't assume our way into a finding of unavailability. It's the government's burden. It can't say just because there were references to a house on Gazelle Street that they're one in the same house. This is, I think the one house number is like 1228, so there's clearly many blocks of Gazelle Street, and there's no way to say that it's one in the same house. In terms of contact with police, that's all well and good, but it doesn't show they made reasonable efforts to locate him at a homeless shelter, which of course is a reasonable place to look for somebody who is homeless. And to say, I can't say whether they would have looked, the point is they should have looked there, and they should have done much more than make a phone call. In terms of whether there was any discussion of unavailability on the record, there was at volume 3, I believe it's pages 12 to 16, there was some discussion at a pretrial conference, and that's where the court said, what have you done to locate Mr. Lozier? And I think you should look at a homeless shelter if there was evidence he was dropped off there. And even if there wasn't evidence that he was dropped off there at a homeless shelter, it's still a place where they should have looked for him, and they didn't. And it's the government's burden, and any factual uncertainties here cut against the government.
What was the length of time between trial and the statement by the family member that he had been dropped off at Tinker Air Force? Was that, was it a year? Was it 6? Do you have any idea what the time
We don't,
difference?
because all the FBI agent's report says is, I spoke to the deputy sheriff on March 10th, I believe, and he recounted that at our request, he had made inquiries. But we don't know when those inquiries were. We don't know when he's reporting that from. So we really don't know. And same as with the uncle's funeral, we don't know how far back in time that was.
I thought they spoke to the family in March of 2023.
No, what the FBI agent says is that's when I spoke to the
To the
deputy sheriff,
deputy,
and he
okay.
reported that
I see.
at our request, but we don't know when that request was.
Okay.
So we just don't know, and what we do know is close in time to trial, they apparently had a residence where they thought he might be. They went and knocked once and nothing more, and they didn't check the shelters. They didn't go to the 3, and there were 3 more they should have gone to.
All right, counsel.
Thank
Thank
you,
you very
Your
much. Your excuse, those were helpful arguments. We appreciate that. The case shall be submitted, and the court will take a brief recess.
honorable judges of the United States Court of Appeals for the 10th Circuit.
Please be seated. Our final case for oral argument is 25-7037, United States versus Underwood. You may commence.
May it please the court. Good morning. I'm Neil Van Dalsum. I represent the appellant, Bryant Underwood. I'd like to begin by addressing the application of 47 OS Section 11-1001. That is the statute that the district court relied upon to find that Deputy Wiles witnessed a violation of a traffic law as the basis for the stop. The record does not support a finding that Deputy Wiles saw a violation of that statute occur because the record establishes that this stop happened in a residence district. And by its own terms, the statute does not apply in a residence district.
And residence is not defined either, right?
Residence is its common meaning, which would be a house.
You don't, but in order to align whether or not the word residence corresponds to the property in question, isn't it best to look at pictures?
That's one thing to look at, and in this case...
Well, so looking at those pictures, it doesn't look like your neighborhood or your residence where people are driving back and forth and the houses immediately next to each other and kids are being dropped off, and it doesn't look like that. It looks like it's pretty rural.
Rural is not the standard. The question of whether it's urban or rural or...
Well, let's not nitpick with words, rural, or it doesn't look like a residential
Unimproved
area.
land is what the district court said. Unimproved land.
What I would ask the
Or
panel...
I mean, the magistrate termed it unimproved land, which is not primarily not residential.
What I would ask is that the court look at the definition itself.
Yeah.
And what the definition itself says is, converted to plain English, most of the property has been improved with a residence.
No, it uses it much more specific. When the property on such highway for a distance of 300 feet or more is in the main improved with residence or residences and buildings in use for business, or buildings in use for business. So it's the property on that highway, and presumably that means the section of the highway we're dealing with here, not the entire highway, has 300 feet or more, it in the main, meaning primarily, I presume, improved with residences. And the district court, it didn't seem to me that anybody testified about this, but the district court said the way to determine that is to look at these aerial views that the state, the exhibits that they had with the aerial views, and the officer specifically marked where he was on this aerial view on Chloe Lane. And the district court said, specifically, referred to the 300 feet or more not being mainly occupied with residences or residences. Quite to the contrary, that section of Chloe Lane Road is mainly unimproved land. She says there's a couple of residences, but they're very far apart. She's very specific about what that shows. Now, I get that it doesn't seem that that's what the officer necessarily testified to, but the district court did make those very specific findings in conjunction with the definition.
The definition...
300 feet.
First, Your Honor, the testimony at the hearing was that Deputy Wiles was watching and saw a vehicle leave from a house, followed that vehicle past 20 to 30 houses.
Right, but we're
then-
talking about the 300 feet. I think that's the important part of the statute.
The 300 feet would be the minimum amount of space.
Right.
If you're looking at an area that is less than 300 feet and it's improved, we've got this tiny parcel that standing alone is not improved, then it's not a district. It's
Well,
just a place with a house.
I think the district court read that to mean the 300 feet essentially where this event occurred. I mean, I think you don't, let's say that this particular road ran for 5 miles
But-
or 10 miles. You don't look at the entire road to determine whether the entire road is a residential district. You're looking at this particular area here where the stop occurred, and he put little X's on the map where the stop occurred, and there were only a couple of residences very far apart in that area.
I would say that if you look at the exhibit that is referenced, the entirety of that road on one side or the other is improved with the residence.
Well, what about that living trust property? Isn't that right in the area where the car was pulled over on one side?
Yes, on
Hey,
the,
look at the picture. What is there that's improved about that other than maybe they chopped down a few trees?
which trust property are you referring to? The
Stuart
area
Bobby W. Living Trust.
below the area where on the picture below where the stop happened?
Right on the right. It's,
Yeah, it's right on
you
Chloe
got the 2
Road.
X's, and it's right
It
next to it on the
extends
right.
from
Yeah.
Casey Lane over to,
On Chloe Lane, on one side, all that property at that location is improved. And if you keep going down the road,
wait a minute, let's not divert to that. The Stuart Bobby W. Living Trust is on the road right by where the car was pulled over, correct?
which exhibit are you looking at, Your Honor?
Well, I'm looking at one of the pictures.
It's the, you can see you can read Stuart Bobby Living Trust on the blown-up aerial map. There's one that's blown up and you can
Exhibit
read it.
7.
Okay. May I grab Exhibit 7?
Yeah, you may.
Your Honor, I have a photo that does not, this one does not have that on there, but I can tell where you're talking about.
So you can't tell me to confirm that the car was stopped on the road and one side of the road where it was stopped is the Stuart Bobby W. Living Trust land?
I can confirm that the property below on the photos where the stop happened does not have a residence.
Right.
Okay, all right, well, that's kind of a yes.
Yes.
All right, thank you.
And the property on the top, just as the district court said, there are 2 residences very far apart next to the road, far apart and behind. One's behind and one's right there, certainly a long distance apart. And as the district court said, the statute requires that 300 feet area to be in the main residential. And she said 2 houses in the main on either side of the street in this large area is not in the main residential. So was that clearly erroneous?
I believe it is because the statute is referring to 300 feet or more. And you don't have to stop and say, we're going to look at this 300 feet.
Oh, do you think it should be anywhere on miles and miles of road, or should it be where the stop occurred?
If you continue going down the road and there continues to
Well,
be
why would it
property-
be, I mean, if it's allowing you to if it's providing, that statute provides an offense that in this case, you can stop someone for this offense, for stopping in the middle of a road. Why would you look anywhere but where the stop occurred?
Because
That makes no sense at all.
the statute is designating for an area, a district, what rules are going to control. If the entire area is residential, there are different traffic rules, different uses of the roadway, different expectations for what activities will take place. And it does not say 300 feet. You just look at the 300 feet. You look at 300 feet or more. The 300 feet requirement is merely indicating that If you've got one house out there by itself, that's not going to be good enough to
So
make
are
it
you
in-
saying that I'm just not following, I guess. If the road is 10 miles long, which it might be, we can look for any 300 feet or more anywhere on the road, but it doesn't matter if it's the area where the stop occurred is not residential. We can look down the road a few miles and it's residential in that area for 300 feet or
Not
more.
if there's a huge break where you have even
Well,
a small
It's
break.
not what the statute, how it reads to me, but I think I understand your argument.
Okay.
Okay.
Let's assume that I agree with you that this is not a residential district and that the magistrate judge was wrong and that Officer Wiles was wrong. We have some cases that suggest an incorrect but reasonable mistake of fact can still justify reasonable suspicion to stop a vehicle. Why wouldn't this fact pattern be a reasonable mistake of fact that would at least permit the traffic stop, even if it turns out the officer was wrong about that?
The officer did not stop this vehicle because of a violation of the statute. The record does not support a finding that, oh, I was confused about whether or not this was in a residence district. If you listen to Defendant's Exhibit 2 at 2950 to a little after 30 minutes, this is 30 minutes into the investigation. And Deputy Wiles says, I don't have anything on the driver. Is she valid? 30 minutes in, he's trying to figure out something that she's done wrong. He's trying to,
They eventually landed on 1001 as the potential violation. And they can do that, can't they?
I don't follow the 1001. What? Oh,
11-1001, that's your residential
They
district.
did not settle on that. They did not give her a ticket. They did not issue her a warning. What they took her to jail over was that she got into an argument with the officer, and he said, well, I'm taking you to jail and saying that the stuff in the car is yours.
Well, that doesn't mean that he didn't have reasonable suspicion and can't cite this statute as a basis for reasonable suspicion. He didn't have to actually arrest her for it.
He never did cite the
He
statute.
didn't have to, you don't have to.
If the issue is, did this officer have a mistake about the law, then I think it's reasonable to ask, did he identify this statute as the reason he stopped the car? And he didn't. There's no evidence that that was his thought process. And in fact, he's out there at the scene 30 minutes after he stopped the car, trying to figure out what violation he has on her, and he doesn't have any. So he's asking, does she have a valid driver's license? Could we get her on that?
But we don't look at his subjective motivations, right?
I think you do if the question is this a reasonable mistake of law? Because I think you've got to have a mistake of law to trigger that. The mistake of law at that point becomes part of the fact pattern. Just like a reasonable mistake of fact, you couldn't say, well, I stopped that guy because I thought he was a suspect, but I didn't. But some other officer might have made that mistake.
Do you have any authority that says in certain special circumstances, the subjective intent of the officer is pertinent at all?
What I have is the reality that the Hine rule
No, well,
has only been applied to actual mistakes. And so if the court says, okay, after thinking about it, Van Dalsum's got a point, this is supposed to be a resident district, the statute wasn't violated, then if the question becomes, well, can we still justify the stop based upon an officer being confused about the law? I think it's incumbent that there be a mistake about the law.
okay, but you address that by means of the reasonable officer rather than the subjective view of the officer in question.
And my response to that is no reasonable officer could say that I drove past 20 houses through a residential area, stopped it because I was concerned about this activity in a residential area, but didn't think this was a residential area.
Would you get back to my original question? Do you have any authority that indicates where we're looking at reasonable articulable suspicion that the subjective intent or view of the arresting officer is at all pertinent?
Not outside of the context of mistakes.
And in the mistake case, you're saying the specific intent of the arresting officer is pertinent and you have authority for that?
That is what the courts have done. That is what the Supreme Court
Can you give me,
did.
just give me a site, give me a name.
In Hine. All of those cases, the analysis of the reasonable mistake of law or fact is triggered by some evidence that there was a mistake.
Well, you're talking about Hine in the Supreme Court,
Yes.
and I am looking at it, and it says searches and seizures based on mistakes of fact can be reasonable.
Correct.
Is your distinction that it would be an objective test for that and a subjective test for a mistake of law?
The objective test is to figure out whether this is a reasonable or unreasonable mistake. But you don't do that analysis unless there is an actual mistake. Otherwise, we have a standard of, well, what could somebody think but didn't think as the basis for a stop?
Well, I think, I understand the confusion here based on the officer's testimony, because he never seemed to, I don't think there were any questions asked of him whether he believed this to be a residential district or anything else, because the fact is, this wasn't the basis for the stop, which doesn't matter. And what he did was just describe, you know, the road he drove along and the houses, and then he put a picture, he drew on the picture where it actually happened, so the area around it, and there's this aerial view, but my impression was they didn't ask him about whether he thought it was or wasn't a residential district, because that wasn't the basis for the stop, frankly. It's the basis they're saying now offers a reasonable suspicion and a reasonable basis for the stop, and that's okay. I see what I'm saying? I see the reason for your confusion, but I don't think the officer ever said one way or the other whether he made a mistake or not, because he really wasn't thinking about this statute at all. He merely described the area and then showed where it was, and then it looked to me like the state used this aerial view to say, hey, you can look at this and you can see that it doesn't meet the requirements, at least under the statute, of a residential district. And that's what the district court said. She said, the evidence that I'm going to look to see if there's support for their basis for reasonable suspicion of statute, the evidence I'm going to look to is the aerial view and where the stop occurred according to the officer. So I get your confusion based on his testimony, but I don't think he really testified one way or the other about this statute or whether he thought one thing or another about it, because apparently he didn't.
He testified that there's 20 to 30 houses
Right.
up and down
Yeah.
it. It's
Yeah.
primarily residential.
Well, he also said things like that to me would about the road right where it happened. It's a gravel road with potholes everywhere, no painted lines or shoulder, brush growing on either side. He described it as also described it as sort of a country area. So to me, his testimony was just a description of the road and a description of the road as he drove along it. And yes, there are, much further away, there are some houses, but not in the area where he was. The road is not, I can't tell how long. There's also no testimony about distances.
The district court relied on Defendant's Exhibit 9. And what I would point out is that what matters under the statute is, has a parcel of land been improved with a residence? Not what's the road, the condition of the road, not is it rural, not how far apart or how large are these parcels? And if you go down that road from where they started to where they ended, there's not a single point that you would not be next to property that has a residence on it. Its residences somewhere to the left or the right and often on both sides the entire way. That's a more than 300 feet section that is in the main improved with residences. It's not a rural-urban distinction. It's a land use requirement. It's a construction requirement. And that's why the district court was mistaken to look at a photo and say, well, this kind of looks rural, so it's not a residence district, because that is not what is relevant under the statutory definition.
I think your time's expired.
I'm way over. Thank you.
Appreciate the argument. Mr. Lehman, you're back.
May it please the court, Jared Lehman on behalf of the United States. It was very difficult for me to kind of wrap my brain around what the standard of review is. What is the court's job, the appellate court's job in reviewing reasonable suspicion? And I think what I've landed on is it is a purely objective analysis. The police officer on scene provides us with the facts. Here's what the defendant did. Here's what I observed. And then we have to take those facts under an objective standard and determine whether a stop was supported by reasonable suspicion. And I'll point the court to two different cases. First, we start with the Supreme Court case in Wren, which is a 1996 case, and then this court in 1998 decided United States v. Galando, G-A-L-I-N-D-O, Gonzalez, 142 F. 3rd, 1217, 10th Circuit, 1998. And what this court held in that 1998 decision was the court's analysis of objective reasonableness is not limited by an officer's own account of his motivation. So what facts do we have? We have a car that stopped in the middle of the road. Full stop. That's what we're dealing with here. Objectively, could a car stopping in the middle of the road support reasonable suspicion for that officer to stop that driver and investigate further to determine whether a criminal offense occurred or even whether a criminal offense didn't occur? And that's exactly what the officer had to do in this instance. The officer had to stop the driver of the vehicle to find out what's going on. Candidly, this statute is a mess. It is remarkably hard to follow. It is just absolutely a mess. It's going to take him eyeballing, okay, the motorist stopped here and it's about a football field length to the nearest house, so maybe I'm in a residence district, maybe I'm not. I might need to get a tape measure out and walk. There's a lot of investigation that needs to go into this, but at a minimum, it's going to start with a stop, a seizure, if you will, because the car stopped in the middle of the road. Now, interesting, this statute, 47 OS 11-1001, sub A, goes on. Unfortunately, throughout the district court level, we only talked about the first part of the sentence, but it continues. But in every event, an unobstructed width of the highway opposite a standing vehicle shall be left for the free passage of other vehicles, and a clear view of such stopped vehicles shall be available. No matter what, residence district, business district, not residence district, not business district, we have to pull over as far as we possibly can to allow traffic to travel freely on the other side. It matters not whether we're in a residence district. Further, even if we aren't in a residence district and it mattered that we were in a residence district, is it reasonable for the officer to have thought that a crime might have occurred? And the answer is yes. And that's all that this case is about. Someone stopped in the middle of the road, and it's reasonable for that officer to have believed that a criminal offense was committed.
Well, the confusing part of this case, though, is that the officer did testify at suppression hearing, and he did talk about the fact that there were 20 or 30 houses on either side of it. which there probably were all along the road, but not according to this aerial map. And so how was that presented to the trial court? I mean, to the magistrate judge, who eventually doesn't even talk about the officer's testimony. She only talks about the aerial map.
I would direct this
It's
court.
kind of an unusual situation that we have here.
It is. I would direct this court to a couple of things in the report and recommendation from the magistrate and then in the final order from the district court itself. And there, they talk about what really matters is the reasonable suspicion of the officer. And that's really the thing that we're here to decide, is did the officer have reasonable suspicion?
Yeah, I get that, I saw that.
So,
But I just, I see the confusion here, and it seems that maybe the state presented some inconsistent evidence in terms of the testimonial evidence versus the aerial evidence. And yet the magistrate didn't address that, and neither did the district court.
yeah, I still don't know that it amounts to any sort of error for that to have happened.
I don't know either. I'm trying to figure that out.
It just simply doesn't matter that they were confused on that issue because they got the ultimate issue right, and that is there was reasonable suspicion based on the objective criteria of there was a stop. And
Well,
so
I presume that the prosecutor who handled the suppression hearing was arguing this particular statute, and presumably was the same person examining this officer, and yet it's like there's no cross between the aerial map and what the district court found and the magistrate found and what this cross-examination was.
As I recall the record, the government examined the witness as to what were your reasons for the stop, and the witness said, I saw him stop in the middle of the road, plus I was doing surveillance on possible drug trafficking, et cetera.
Yeah, I'm talking about his description of the road, which is what we have to look to in terms of, was it a residential district? And
Right.
that part seems possibly inconsistent with the aerial map.
I don't know that the witness, in fact, I do know that the witness was not put to the ultimate question of, is this a residence district within the legal meaning of Title 47 of the Oklahoma
Right, I don't think
statutes.
there was anything like that,
So
right.
is it a residential area, I believe was the term of art that they used in the suppression hearing. And that's just an unfortunate term of art that got used in that hearing, and instead of the legal terminology from within Title 47. But again,
Well, what's the 300? Can you explain the 300 feet to me? I'm kind of confused by that.
Your Honor, regrettably, I'm equally as confused. Again, this statute could not, I hate to be critical of the state legislature, but this statute is just terribly constructed. If you read it strictly, you could have an area of 300 continuous feet where you have a residence district, and then you have a small cow pasture, and that's not a residence district, for 301 feet. And then you could have another residence district for another 100 feet, because there's two houses there, and they're just large acreage houses. It's just impossible to put all of this together as to what it means. And so, interestingly enough, I think that feeds right into Hine v. North Carolina, the Supreme Court case that says, listen, even if the officer was mistaken, given the convoluted nature of how these statutes all work together, and how it's extremely hard to even get a determination on what these mean, I think that if the officer was factually mistaken, Hines supports a finding that that was reasonable.
Well, that doesn't really apply here because we don't even have an officer that even knew about this statute or is suggesting that, I mean, it doesn't make much sense here when we're basically concocting a reasonable suspicion, a basis for reasonable suspicion after the fact.
Right, Your Honor.
It just doesn't, the mistake doesn't work.
Even if it doesn't work, we still go back to factually a car stopped in the middle of the road. Was it reasonable to believe that a crime occurred? The answer is yes, Your Honor.
Yeah, well, your problem is we're backing into, it seems like it was stop first and justify later. And, the case law to some extent permits that. So you're back, you're scurrying through the code. Okay, what do we have that might work? And then, okay, there's this statute, or this one does work, but, you've got to get the witness to, give us the factual background to make it work.
Even under a traditional reasonable suspicion stop outside of a verifiable traffic violation. The facts in the record support the following. It's after 11 p.m. at night.
So you're saying even without 10:01, there was still reasonable suspicion?
Yes, Your Honor. Yeah, when you look at the totality of the circumstances, the building blocks to the reasonable suspicion, the late hour, the fact that the police have suspected drug activity in the area, they're doing surveillance actively on that drug activity. This officer just isn't on routine patrol. He's surveilling what he believes to be
I
true.
didn't think you used that in your briefing as a basis for reasonable suspicion. I think you used it was high crime area and it was late at night. I mean, I don't think you said that, because you're surveilling this person for.
Correct, which would make it,
That'd push it.
but which would make it part, so the surveillance in and of itself, just because an officer's doing surveillance somewhere, doesn't mean that that's reasonable suspicion. I saw you when I was doing surveillance.
Right.
But the fact that it was surveillance in a suspected drug trafficking area, I saw this stop happen at 11 o'clock at night in a suspected drug trafficking area, and
This whole, that doesn't really fit with this whole idea of it being not a residential district and being not a business district, but being undeveloped land. It just doesn't sound like your normal high crime area.
well, Oklahoma, especially the
Undeveloped land,
Your Honor, with,
high crime area, country road.
Your Honor, the Eastern District of Oklahoma is a remarkably rural area.
Well, I don't know about that, yeah.
I'll represent to the court that it is. We do not have a commercial airport, for example. All that being said, Your Honor, there's more to the traditional reasonable suspicion argument. We have the drug trafficking area, we have the stop at dark. This isn't a place where pedestrians would be. There's not really a reason to be stopping in the middle of the road and letting pedestrians in and out in a normal.
Well, there was a driveway there.
Correct.
There was a residence.
Correct. So if you were going to drop
I don't know
pedestrians.
why that would be that unusual.
Well, if you're going to drop pedestrians off, you would use the driveway. This is a very
Well, the
dark.
officer wasn't even consistent. He said it was either two people getting out or one person getting in.
I think ultimately he lands on the fact that two people got out.
I think the magistrate landed on that, but I didn't see that in the testimony.
With respect, Your Honor, I would refer the court to the officer's written report.
Yeah, well, it's inconsistent with his at-the-time report.
Sure, he does make an excited utterance on scene in his body camera, but later on when he writes his report and then testifies at the suppression hearing, he's very clear. Two people, I don't want to misspeak. I can't even remember now if it's got out or got in.
Says two people get out, but he's at a driveway. I'm not sure why that's so suspicious.
Well, regardless, when you put all of those things together, Your Honor, I think that the reasonable suspicious analysis survives any sort of scrutiny that we could give. We have a stop in the middle of the road, late at night, pedestrians where pedestrians probably shouldn't be. There's reported drug trafficking in the area. So this is honestly, I think, a very justifiable stop by the police officer. If there's no more questions, I would ask the court to affirm the defendant's conviction and sentence.
Okay. Thank you, counsel. Counsel's excused. Case is submitted. We appreciate your arguments. And the court will be in recess until further notice.